Forum. We also have some members who are joining us on this computer program, and I want to welcome all of them here. Today is our second study committee meeting on the subject of foreign ownership of our farmland in Mississippi. And we have not a full agenda, but we have a very in-depth agenda today. We have a guest speaker. We're bringing in an expert from the National Agricultural Law Center, and he's going to be making a presentation to us in just a moment. And I'll properly introduce Micah at the right time. But for now, the first thing we need to do, ladies and gentlemen, is I'm calling this meeting to order and declaring that we do have a quorum. There are minutes before you from our August 24th meeting. I want to thank our official secretary, Madam Chairman. Appreciate you taking care of that. And Juan also who assisted, so thank you. Do you have any changes, additions, edits, or anything else to these minutes? Anyone? Okay. Seeing none, is there a motion that they be approved? There is a motion. There's a second? Second. All in favor say aye. Any opposed say no. Thank you. Now, one matter of business, the only vote that we're being asked by the legislature to take is to submit recommendations to the legislature by December the 1st. So I did not bring up the subject of rules to abide by for the purpose of conducting this meeting, and those that vote are votes. So is there a motion that we adopt a set of rules to conduct business as this task force committee?
Mr. Chairman, I move that we adopt a set of rules, and I move that we adopt Robert's Rules of Order as well.
Thank you. The motion is to adopt rules as Robert's Rules of Order. Is there a second?
Second.
Second. All in favor say aye. Aye. Opposed say no. Thank you. Thank you. Yeah, we don't have a legislative matter before us. This is going to be a packet of recommendations that we hope to have assembled in November for submission on time by December the 1st. Is there any other business that any member of the committee would like to bring at this time before we get into our presentation? There will be a presentation in depth, Micah has told me, and an opportunity for the committee to ask questions, and then we'll have an opportunity for the audience. We want to welcome all of our guests and visitors today and members of the public. There'll be an opportunity for you at some point to ask a question. We will operate within the bounds of time, and then we will conclude this meeting. Any other business by the committee, Mr. Chairman? Thank you.
No, sir.
Thank you. Any other members? Thank you. As a reminder to the public, we have established a website so you can watch the activity of this study committee. We have established a dedicated email address, which is farmland at mbac.ms.gov, that you can email your comments to. We've already received a number of comments and information, and those are included in your packet. And of course, we'll make all that part of our report to the legislature. But for now, I want to recognize Micah Brown, who is staff attorney with the National Agricultural Law Center. And Micah received his Juris Doctorate from the University of Arkansas School of Law after earning a Bachelor of Arts in Political Science from University of Central Arkansas. While in law school, Micah worked as a law clerk for the Office of the Arkansas Attorney General in Consumer Protection. During his time there clerking, he worked on various agricultural, environmental, and public utility law issues. During his second year of law school, Micah began working at the center as a research fellow, and after graduating law school in May of 2020, he joined the center full-time. At the center, his primary areas of research are finance and credit, commercial transactions, secured transactions, federal crop insurance, and our topic today, foreign ownership of agricultural land. So Micah, we appreciate you being here. Those of you who may not know, the National Ag Law Center is a great resource for all things in the world of agriculture, and it is based at the University of Arkansas. So Micah, welcome to Mississippi, and we look forward to hearing what you've got to share with us today. We want to learn from that. We want to hear what other states have been doing, what Congress may be doing, and we will then have committee questions for you, I'm sure. Thank you. Welcome. Y'all welcome Micah. I'm circulating a sign-in sheet so everybody can sign in. And for those who are on the internet, our staff is going to make this presentation available to you to watch on the screen. Thank you.
First of all, I want to thank y'all for having me down here. Anytime I can come to Mississippi, I'm open for it. I love driving through the Delta. And what I pass out to the committee is all of our resources that the center has published or has made on this issue, just scanning that QR code. So a little bit about the center. We were established by Congress back in 1987 in the wake of the farm crisis to help anyone that might need legal resources that is in the ag industry. And so Congress established us to be an independent, a nonpartisan, objective resource, and that is what we provide today. So the feed, QR code right there, anything to do with foreign ownership throughout the nation, particularly the federal level and all the states that are active in this area, an update will be in the feed, which is just our bi-monthly rundown of all ag and environmental policy. So foreign ownership of ag land. At the federal level, there is no restriction on foreign ownership. They do have the Agricultural Foreign Investment Disclosure Act, or FIDA. Congress established this to pretty much keep tabs on what foreign entities have an interest in ag land, or foreign persons or foreign governments have an interest in ag land in the U.S. So the most recent data that we have is through December 31st, 2021. Foreign ownership of private ag land just crossed a threshold of 40 million acres. This is a 2.4 million acre increase from the year before. And over the last decade, you can see over 14 million acre increase, or 35% in private foreign owned ag land. You can see majority of this, almost half, is in forestry land. Then we followed by cropland, pasture land, and other ag. And USDA has not established a definition of what other ag is. Most likely these are leases that are 10 plus years, long-term leases, and likely wind and solar energy leases. So breakdown here, Canadian investments, number one on the list and have been for a long time, followed by the Netherlands, which Netherlands own the most foreign held ag land in the state of Mississippi. You can see the list there of the states where most of the foreign ownership is. This last report that USDA published had Mississippi at over 750,000 acres of private owned ag land, private foreign owned ag land. You can see Chinese investments are less than 1% under this USDA data. Here's a heat map kind of just to demonstrate where a lot of the foreign ownership is, and you can see the South has a lot of foreign ownership, and the corners of the U.S. there, just right next to Canada, and lots of forestry there. So there are quite a few federal proposals on restricting foreign ownership, and we can go into those a little bit later. My boss is actually Harrison Pittman is in DC right now testifying for the Senate Ag Committee on foreign ownership at the moment as we speak right here. He likely is speaking at this moment. So, but at the state level, you can see the states in red are the ones that have a restriction, some kind of restriction on foreign ownership. There's 24 of them. The states in green are the state in their state code that expressly permits foreign ownership, and the states in blue are the ones that are silent on the matter. Really, this has been an issue since the founding of our nation. It was actually a reason for breaking away from the crown was how England dealt with alien ownership, foreign ownership, and that was cited in the Declaration of Independence. So this is just the most recent political flashpoint that this issue has appeared. And it really started in 2021, where we had a lot of media coverage on a Chinese company in Texas was purchasing land and got pretty close to Air Force Base, and then roll over into 2022, we get a lot more media coverage on a different Chinese company purchasing land near Air Force Base in North Dakota. So you can see we had 12 states have some kind of proposal. The one in Mississippi was just kind of to amend the current law to include an exception in a way for the foreign ownership law for very specific industries. Indiana was the only state to really enact a foreign ownership law during that time frame. We jumped to 2023, we have 35 states having some kind of proposal to restrict foreign ownership. As a result, we have 12 states enacting some kind of law. North Dakota and Oklahoma amended their law, so we have 10 states that didn't have a foreign ownership law before 2023 enacting an ownership list. So you can see just the comparison from 2022 to 2023. We can see the South really filling out on restricting foreign ownership. We're going to go through some of these southern states. The thing is, these foreign ownership laws, because they were developed over time, through our nation's history, sometimes decades in between actually looking at this issue, they developed unevenly, they do different things, use different language, different approaches, and so not one foreign ownership law is the same, and so hardly any uniformity. But one thing that really sticks out to me from the pre-2023 laws, the 14 states that did have a restriction, and I call those kind of the traditional foreign ownership laws, they're very broad restrictions. They use language that, like non-resident alien, a foreign business entity, that would encompass anyone from a Canadian investment to a Chinese investment, a Netherlands investment. And then you come into 2023 where almost all the states, besides Idaho, enacted a law that restricts specific investments from specific countries. And Alabama, you can see, they restrict foreign principles from foreign countries of concern. That is going to include a government or a political party of what I call the Big Four, and that's going to be China, Iran, North Korea, and Russia. And you can see that language. That restriction is specifically restricting the government from those four countries from purchasing land, specifically ag land and forestry land in the state. So something that really kind of sticks out to me in this is that they use language purchase or other acquisition of title. That seems to indicate that leases are not covered in this, and a lot of foreign ownership is in long-term leases, sometimes up to 99 years. And so that is something that a lot of foreign ownership laws do cover leases, but this one seems to not by the language. They exempt anyone that's in this transaction, brokerage, real estate, brokerage firms, title companies that are insuring these transactions from liability when a prohibited foreign purchaser comes in and purchases it, they will have no liability on them. But something that's really interesting here is that there's no enforcement or penalty provision in their law that they just enacted. you have to have enforcement. You have to have an enforcement provision. A lot of states kick this to the state attorney general to bring an action for forfeiture. And then obviously there's generally a direction where the court should go or how the court should rule if they find a violation. A lot of it is declaring the land escheat to the state and having the land sold at public auction is going to be the order. But you don't see that in Alabama law. Arkansas is another state to enact a law. Back in 2021, they had a proposal that was very similar to Missouri's law, but Missouri kind of has a history in their foreign ownership law, especially in 2013 when a Chinese company acquired Smithfield Foods. So that it wasn't really workable in Arkansas because of that history and the context. So it ended up being a reporting law that coincided with the federal reporting requirement of FIDA. And so, but in 2023, Arkansas enacted SB 383, which restricts prohibited foreign parties from obtaining any interest, which would, by that language, include any kind of interest, including leases, in purchasing ag land, acquiring ag land, or forestry land. And so, under this one, you can see, as opposed to the Alabama law, where that one specifically restricted governments and political parties of the Big Four, Arkansas's law restricts individuals, entities, and governments of countries that are subject to ITAR, which is going to include the Big Four or entities of particular concern, which are federal definitions. You can see that Arkansas is attaching who is prohibited in their country to a federal definition, which you can, that's what a lot of states did. Alabama and Florida, Alabama kind of did to a sense, but Florida, which we'll get to next, doesn't use a federal definition. So even domestic companies and non-ITAR entities can be a prohibited foreign purchaser if there is a significant interest or substantial control, which is 33%. So if a prohibited foreign party holds 33% in this U.S. entity, they are considered a PFP and restricted from purchasing ag land within the state. Something that's interesting, no grandfather clause. A lot of these foreign ownership laws have grandfather clause to pretty much permit whoever owned agricultural land before can continue to own, but they cannot expand. Arkansas doesn't have an express provision for that. And there's no research or experimentation exception, which, if you think, that's really crucial to a lot of crop protection, the seed and feed companies, because they do a lot of research, obviously, experimentation on this. And without that, it doesn't seem like there can be any expansion for these companies that are Arkansas. And throughout the South, and specifically in Mississippi as well. Lots of crop protection companies have lots of interest in this state. So something interesting about Arkansas's law is that they created this Office of Agricultural Intelligence. And they're the only state to create a board to actually specifically investigate foreign acquisitions that are in violation of this law. And then they will report their findings. If they think there's a violation, then they're going to report that to the Attorney General, and Attorney General is directed to investigate and enforce this law. If there is a violation found, the court will order a judicial foreclosure of public sale of the prohibited held land. And Arkansas did something pretty interesting too, is that they attached criminal liability to their foreign ownership law. No other state had done that. And Florida actually followed suit with this and attached criminal liabilities, but they're the only two states that have a provision like that. Arkansas took it a step further and actually restricts prohibited foreign party controlled businesses, which is going to be 50% or more in an entity owned by a PFP, from acquiring any real property within the state, not just ag specific. Florida, they restrict foreign principals, which is going to be individuals, entities, and governments of a foreign country of concern, and they name the Big Four, plus Venezuela, Syria, and Cuba. They had 3 kind of restrictions under their law. One was ag land specific. One was land 10-mile radius within a military installation. And the third was specifically restricting Chinese investments for people, entities established in China, the government of China, and people domiciled in China that are citizens living in China from acquiring any real property. And see the criminal liability attached to that. There's also criminal liability for individuals that knowingly sell to a prohibited foreign purchaser. There is a lawsuit right now in the state of Florida pretty much challenging this foreign ownership law. It's for Chinese citizens that are temporary residents of Florida, living in Florida, have challenged this law, stating that it violates their protections, it's a violation of due process, violation of the Fair Housing Act, and it is actually preempted by federal law. There is this regulatory board or enforcement committee that is a multi-agency committee called the Committee on Foreign Investments in the U.S., or SUFICE. They will review potential foreign purchases that have a potential to or pose a threat to national security. And they can say yea or nay to the president, and the president can move forward and say, yeah, we're not going to let this transaction go through. The plaintiffs in this case were saying that the federal law SUFICE preempts what the state is doing. They filed a motion for preliminary injunction, meaning that they did not want the state to enforce the law while the lawsuit is active. The judge actually denied that motion, stating that these plaintiffs likely not going to win the lawsuit. They are appealing that right now to the 11th Circuit. Louisiana was another state. They had actually two measures that passed their legislature. One was an ag land specific restriction that actually included a research and experimentation exception. This is the one that was signed by the government. The other one was vetoed. This one was signed. They're restricting foreign adversaries, which is a federal definition determined by the U.S. Secretary of Commerce, and that includes the Big Four plus China, Cuba and Venezuela. And this is a not just, like I said, ag specific, but all real property within the state. There is no requirement for attorneys or real estate agents or brokerage firms to investigate when they're brokering a transaction. There's no liability on them. But there is liability if you knowingly aid someone of the Big Four from purchasing real property within the state. There's an enforcement. State AG is authorized to enforce, and it's going to be sold. Louisiana is a little bit interesting because it opens up the door for private sales of this agricultural land, of this real property that's held in violation, not just a public sale. Oklahoma, they amended their foreign ownership law. I think the way that I read their law is that they narrowed their restriction, because it seems like that the language used to apply to foreign persons that not citizens of the U.S. from purchasing real property, not just ag land, but real property within the state. State legislature went and amended that to say that foreign persons cannot purchase land through a business entity or trust to pretty much break federal law or be active in some kind of enterprise that violates federal law, aka marijuana production. And so it really narrowed the circumstances when there's really a restriction or when there's a violation within the state. They also require buyers of land now to sign an affidavit going through that big stack of papers when you're buying property that says, I'm not going to violate this law, or I'm not attempting to violate this law. But again, very narrow circumstances where the restriction actually plays a role here. Tennessee, they enacted a restriction on non-resident individuals, foreign business entities, and foreign governments of sanctioned countries. That is determined by the U.S. Treasury Department. So there's another federal definition. We have a lot of states using several different federal definitions on who actually the foreign buyer is restricted, who is being restricted here. Something that's really, really interesting about this is you can see some of these states are exempting individuals and parties that are involved in these transactions that could potentially be a violation. They're exempting them from liability. But Tennessee's law specifically states real estate brokers, real estate agents, attorneys that are licensed in Tennessee are exempt. So anyone in Mississippi, a Mississippi attorney conducting a deal, it doesn't seem like they would be exempt from liability in that state. Virginia, they were kind of interesting. I included them. The legislator sent the bill to them, and it had a provision in there. It's the second bullet point. Any acquisition in violation is void. So anything that restricts is a restricted transaction, it will be void. Well, the governor got a little pushback from real estate lobby saying, hey, this could really affect us because we're the ones that are insuring these transactions. And if a transaction violates public policy, then we could get knocked. And then there could be a break in title. So the governor sent back substitutions to fix this where title would vest in the state from the date that the prohibited foreign party purchased the land or acquired the land. So there wouldn't be a break in title. And you can see again, this one, Virginia uses the term foreign adversary, which again, you can see other states did use that foreign adversary definition, which includes the big four. Mississippi. So there are some laws, as y'all know, on the books. There is, in Mississippi Constitution, it directs the legislator to enact some kind of legislation that restricts non-resident aliens from acquiring real estate within the state. And then it goes on and says, and may limit or restrict lands by foreign corporations. Second one on the list is a public lands restriction.
Mike, can I correct you? It says corporations, not foreign.
Not foreign corporations. It does say corporations, but it leaves it very broad. So U.S. corporations, I guess, can be restricted as well within the state. The one at the bottom is the foreign ownership law that's been on the books for a very long time. States non-resident aliens from acquiring land, and there are some exceptions to 320 acres for industrial development purposes, and 5 acres for residential. And it does mention some language about corporations being exempt from the acreage caps, but under the language, it does not seem to indicate that foreign business entities are restricted in a sense. But the language in there can indicate that foreign entities are. For example, the first 3 paragraphs in that law states that it seems directed towards foreign individuals that are non-resident individuals are restricted from purchasing land within the state. And then go to that bottom where it lays out the exceptions for 320 acres for industrial purposes. The law continues and says, under this paragraph, corporations that are wholly or partially owned by non-resident aliens are exempt from this restriction. So if you read the first 3 paragraphs and look at the Constitution, it seems, if you take that all into context, the fact that the Constitution says non-resident aliens and then has a separate portion where it goes on and talks about corporations, it seems that the term non-resident aliens is only including individuals. But when you read the foreign ownership law and it starts including exceptions for wholly owned corporations, it seems kind of out of place. And like it kind of doesn't make sense that it's there. Because if they're not restricted already, why would you need an exception for corporations and entities? So, but there is no enforcement provision within the actual foreign ownership law. Mississippi's Civil Procedure Code has this legal action, quo warranto, which is a Latin term that I am probably butchering, but even attorneys in the room are probably like, I've never heard of that, because I hadn't ever heard of it, and that's something you just don't learn in law school. This legal action is generally for requiring a person to state that they have power in their office, their official capacity to make decisions, but it lists 10 different situations where the Attorney General or a district attorney can bring one of these legal actions. And number 10, the last one on the list, is when non-resident aliens or corporations hold land that violate state law. And then you can see the 11-39-3 is directing the Attorney General or a district attorney to bring a lawsuit in the county where this land is held in violation. So even though that enforcement provision is not in the Mississippi Foreign Ownership Law, there is a part where it could direct the Attorney General to bring a lawsuit under this. And foreign ownership law, Mississippi Foreign Ownership Law, this slide, there is actually a penalty, no enforcement, but penalty, and land is to escheat to the state that is land held in violation. So I will open myself up for any questions by the committee.
Thank you. Thank you, Michael. This is really, really informative and very helpful, I think, to see. I know you didn't cover what every state is doing out there, but you covered the ones that are around us and how they're going about it. How many states did you say have done something like it in 2023?
There were. That'd help. There we go. In 2023, we had 35 states that had proposals. We had 12 states that enacted some kind of restriction. 2 states, North Dakota and Oklahoma, they amended their laws. So we had 10 states that enacted some kind of new restriction that did not have one previously.
It looked like the bulk of them were kind of in the South.
They were in the South.
All right. Well, I'm opening it up to questions from the committee. If you are online, if you're on the committee, you can do whatever you need to do to be recognized to ask a question. But here in the room, does any member of the committee have any questions at this point? Yes, Mr. Kendall.
I'm curious about what's being done federal level and how it affects these you often pointed out on the state.
Yeah, that's a good question. So there are several proposals at the federal level. And I've broken them down kind of in categories. Some are restrictions, direct restrictions, kind of using similar language as the states do. Just about all of them are directed towards restricting the Big Four. Some are specific to restricting investments, Chinese investments. Some are restrictions in ag land or real property from multiple countries, namely the Big Four. There is one provision that says foreign persons, restrict foreign persons from acquiring ag land within the U.S. That includes pretty much anyone, Canadian investments or Chinese investments. There are proposals that amend CFIUS, which I referred to earlier, which is this committee that looks at foreign transactions that pose a threat to national security, or they determine if they pose a threat to national security. Agriculture is not part of the review process under statutory law. There was a hearing, the House Oversight Committee did a hearing on suffice to determine where agriculture plays a role in this currently. They did state, the representative from the Treasury Department did state that, yes, we contact USDA, we are, when a transaction covers agriculture, or could include agricultural land, but their CFIUS, their jurisdiction is very limited. They have a 100-mile radius around certain military installations. So a lot of that could cover ag land, but at the same time, it doesn't go as far as what these states are doing. And that kind of goes into the second question: how would those federal laws interact with state laws? Well, so that would be a question of preemption. And without explicit or expressed direction from Congress saying this law right here is going to preempt these state laws, without that, then it would pretty much have to be kicked to a court to decide if a lawsuit did arise. And generally, courts will read or determine a preemption suit. They don't want to take away more than they have to from a state. And so generally they look at a federal law or federal regulation in an area as the base, and states are permitted to do more as long as it does not conflict. And reading some of these foreign ownership laws seems that they do the same thing, and some states go a little bit further. So many of the provisions, if not all, would be parallel, I guess, with the federal regulation in this area, as to where the federal law would not preempt state laws. They can continue to regulate in their state. And traditionally, this has been a state issue. So they don't want to take away from historically what is granted to the states to regulate.
And you said there are pending federal proposals up there in Congress. Not that I have a whole lot of confidence in Congress to pass anything, but how many of those are pending right now? Do you know?
I don't have an exact number, but I would say restriction-wise, that specifically look to restrict foreign ownership, possibly 12 to 14, and they all do something different or overlap quite a bit as well.
And if our members of this committee sign up for your email list, you send that out once a week, is that right?
It'll be just about every other week.
And do you capture all that and send it out?
I do. Any kind of update, any kind of movement on those will be in that.
Good. Mr. Pendle, will that answer your question? Okay. Any other questions about the committee? Okay.
I have a question, Mike. Under some of these other state laws, how have you seen any real life examples of them instituting enforcement actions?
So that's a really good question. So the answer is no. Because these laws are so old and kind of forgot about, to a sense. I mean, I've spoken to quite a few people in states, and they're like, I didn't even know we had a law. How long has that been on the books? Well, it was actually enacted in the 1700s. And so it has some dust on it. But Wisconsin, there was a state Supreme Court decision. It was a partnership. It was a German partnership, and they own some ag land within the state, and Wisconsin has had a restriction for many years. It was challenged, and the state Supreme Court actually upheld the restriction, that's kind of, there's been two challenges to these foreign ownership laws, and that's one. Another one was in the 8th Circuit over a Missouri law. until we have now the Florida lawsuit challenging their foreign ownership law. But after that lawsuit, around the time of that Wisconsin lawsuit, Wisconsin Attorney General sent out some letters saying, hey, foreign entities, you need to divest, or we're going to come and deem the land escheat to the state. I don't know, I have not seen any follow-up to that, or if there was any follow-up during that time. It's almost been 40 to 50 years ago when this occurred. But to date, that is the only enforcement I've really actually seen from these laws. But with so much attention on foreign ownership laws, especially these 10 new states that have enacted something and have put it, Arkansas, for example, actually creating an office under their ag department to investigate these, we might actually see some enforcement now since there's so much attention.
So, again, we don't have any state that has actually, taken back title to any ag property yet.
From my knowledge, there has not been any kind of action like that.
Thank you. Wiggins, Chairman Wiggins.
Thank you, Commissioner. Only God knew all those years driving to Pine Bluff, Arkansas, through the Arkansas Delta, did I think I'd be on this committee, which is great. I'm really interested. Where are you from, Arkansas?
Salem County from Benton.
Benton? Okay. Jonesboro and Pine Bluff. So good stuff. I have two questions. And I guess it's because my role as chairman of Judiciary, I think of these things. But when we do things that even smell of eminent domain, the legislature, people come out of woodwork, rightfully so, talking to us. If I understand what's going on, and my point is that because it's private land and the government, eminent domain, government is taking people's land. We, with these laws, are telling people what they can and can't do with their land, be the government. So why, I guess my question is that how you see it? And I noticed, by the way, that our Constitution says public lands. Are these laws telling private landowners that they can't sell their land to certain individuals or companies? Now, let me say, I certainly agree that we have a role to protect our country and our state from foreign threats. That's our job. And so what I would call the competing interests here are protecting our citizens from foreign threats, but then the government telling private landowners what they can do with their land. Mm-hmm. What's your comment on that?
So, how I read most of these laws, and specifically Mississippi, it does not have any provision in there that would place liability on any seller of agricultural land. It's a restriction on the actual purchaser, the foreign purchaser. So, under the language, it seems that the seller of this ag land, or any real property in Mississippi's case, there is no restriction, or the government is not particularly telling them they cannot sell that land to this person. The violation comes where the buyer actually purchases this land. So a law like this, that is kind of one of the unintended consequences, though, is you might not have the market of buyers that you maybe would in other states that don't have a restriction.
Okay. To me, that's a very important distinction because the laws that are being passed they're not telling the seller they can't do it. But I guess the practical effect, what you're saying, is in the marketplace, because they're saying the buyers can't do it, there's nobody else to buy it. So practically speaking, the government is telling private landowners they can't sell. If the only buyer they have, let's say, is the Netherlands, government is telling them you can't do that. Is that right?
Practically, that could be unintended consequence of a law like that, yes.
So are people raising concerns that the government is telling these private landowners that they can't sell their property?
There has been, particularly some interest groups with raising that concern. Yesterday or a couple of days ago, there was some farmland sold for $34,000 an acre in Missouri. That actually caught my attention. And I'm assuming that some groups will point to this and saying, like, even though I don't know actually the details of the transaction or who was behind fronting that money for that, but that's an example they point at and saying, this is a consequence of not having a law like this, is that it could reduce the price for farmers trying to sell ag land.
Okay, so should the legislature go forward in, let's just say, making such laws, should we be concerned that, one, we're going to get people raising concern that you're telling private landowners what they can do, and number two, that we're going to be facing litigation, be it either constitutionality or something else? Is that, if we pass such a law?
There could be some consequences to passing a foreign ownership law, just like Florida. A primary issue when enacting these laws or drafting these laws is, and it sounds very basic, but looking at the actual definitions, what got Florida kind of wrapped up in some of this in the courts is that they did not define what domiciled in China means. And the Chinese citizens that brought this lawsuit said the due process claim was, we don't know if this applies to us. What does domiciled in China mean? And so that was one big issue that the courts are dealing with and going to continue dealing with. So definitions are very important in how you define which parties are restricted. There's other consequences in the ag industry. Like I said, crop protection companies can be a big issue in this state. There's a lot of forestry. That is another thing. That is another consequence that could happen. When you tailor these laws to specific countries, like most of these 2023 states did, that doesn't raise as much concern, especially in the forestry industry. Then you have non-ag industries as well. That's kind of another unintended consequence to some of these restrictions is one that I've thought about is car manufacturers. There's been instances where they might not feel welcome to put a Toyota plant somewhere in your state. Grain elevators also could be another unintended consequence. And there could be some kind of level of foreign ownership under the actual LLC that owns the grain elevator.
So in other words, just to sum that part up, we have to be careful because otherwise we're clamping down on what I would call economic development in the state.
It could be a consequence.
So that leads me to my next question, which is these laws that have gone through the states, and you mentioned the big four, and then I was also looking at what Mississippi's Constitution says, and as we all know, it dates back to 1890. Is what we're afraid of, is it the big four, or is it all foreign ownership? And partly the reason I ask is because if looking at your own information, and if I remember from our previous meeting, the Netherlands actually own the most foreign land in Mississippi. So is our goal to prevent the Netherlands from owning it, or is our goal to prevent China from owning it? And then looking at your information, Canada is our largest foreign ownership in the U.S. So are we saying we don't want Canada to do it? And then if we're talking about threats, if you just base it on the numbers, what I'm looking at, if I understand right, I think you said China owns 0.2% or 0.3%.
Less than 1%.
Okay, so if you're looking at numbers, they're not even a threat.
Mhm.
Is that, so what are we trying, where is this coming from, or what are we trying to get at?
Mhm. That is a really good question for
Can you repeat that?
it was a really good question for the legislator.
Thank you.
Not me, the legislator, but I will say that most of these, the proponents of these measures have claimed national security. And that is what I've seen over and over again at the national and state level, is that the purpose for proposing these or enacting these is to protect national security or state security.
Which, okay, fair enough, which would then, I certainly have my fears about China and Russia versus the Netherlands and Canada. So that seems to lead to the question that if you're going to do such things, it needs to be tailored to those that we fear versus those general ones. But then I go back and look at the Mississippi Constitution provision, and nothing in there says fear. It says foreign owners, foreign individuals. But is that, I guess, what you're cautioning?
So even though these laws have, give a little bit of background, a little bit more, even though these laws have developed over time, even since the founding of our nation, they have primarily been enacted for national security reasons. And so that has always been the thought or the purpose under these laws. The parties may have changed. In the 1700s, it was British loyalist. Fast forward to 1970s, it was countries of OPEC. It was these oil countries. Back up a little bit, 1880s, it was rich European investments in the West. They were concerned about colonizing, so states were enacting these laws to prevent a takeover or national security concerns. And then fast forward to now, we have a new bunch of parties that states are intending to restrict. And I will say, even though the data on USDA does show that Chinese investments are less than 1%, I will just make this little comment. A FIDA is a self-reporting statute. So it is based on the entity or individual to report their foreign ownership to USDA.
And so in conclusion, with that, so could it be said that the lack of enforcement provisions or the lack of, following through over time could be that this is a flashpoint throughout dating back to the founding of the country, and it just kind of is like, well, we don't need to do it because it's just what happens kind of thing.
I don't know if I understand the question.
So is the lack, when you get into the enforcement, which is then what I would call triggering, so let's say the law's passed, and then you enforce it, and then a private landowner says, well, you know what, I'm trying to sell my land to the Netherlands or wherever. They're the only ones, and you're telling me that I can't do it. And then that's arguably a violation of their right, freedom to contract and freedom to have land. So then you enforce it, and then you're getting into lawsuits and constitutional arguments. And so then when people start to think about the enforcement side of this, they go, oh, wait a minute. And we don't want to go down that road. This has been going on since 1776.
Mm-hmm.
That's where I was about.
There could, yes. I mean, in that instance, in a lawsuit arised, a judge would have decisions to make on that and have to weigh the balances of likely the purpose of the legislation, which would be national security threats, state security, and property owners.
Okay, thank you very much.
Madam Chairman, Dr. Hammond, you're looking at.
Thank you, Mr. Chairman. So during your presentation, I found really interesting for some of the states, for instance, Louisiana and Tennessee, where they didn't make requirements for the attorneys or the real estate agent or the title examiners to do any sort of investigation, and I think maybe it was Tennessee where it only applied to Tennessee counsel. So then, if for instance, a Mississippi or Louisiana attorney or any other state other than Tennessee, that attorney, et cetera, would then have some responsibility under Tennessee's law. So when Ms. Listcom asked a few moments ago about the enforcement, I think the response was there have been very little. So my question is, seeing those states, for instance, Louisiana and Tennessee, where they have kind of leveled out an exemption in the statute, have there been any cases or any kind of enforcement against, say, perhaps an attorney or any real estate agent, or was this the state's particular way, in your opinion, of just saying, okay, we're not going to impose any specific requirements on those specific professionals?
Yeah, there hasn't been any instances where I've seen of any enforcement coming after brokerage firms, title insurers, and attorneys. The second part of that, politics works in interesting ways, and I assume that there is plenty of attorneys hanging around the legislator and plenty of real estate lobbyists hanging around as well that are very interested in a law that restricts foreign ownership. It could be clients or restricting land. So I assume where some of these states threw in provisions like this, there was likely parties behind the scenes likely saying, hey, we could get knocked for something like this, just doing our job. So I assume that's kind of where some of that came from, because that didn't appear pre-2023.
Well, I'm an attorney, and when I saw that on the screen, I love the provision, by the way. And so I just wasn't sure if you had seen any cases or anything like that where maybe someone there was some kind of lawsuit or something of that nature. But thank you.
And I'm going to have other committee members to ask any questions, but I have one in light of what both of you talked about. And what piqued my interest was you said if the court were to get a law, if we were to pass a law, if this legislature were to pass a law, and the court were to get it, you said the purposes of the law would be key in determining a lot of different things. Have these other states put a preamble as to what they're trying to accomplish in their laws? Is that important for this body to consider for the report we're going to provide? Is that significant? Should it be part of the action if the legislature so chooses to act?
Yeah, I've seen it not in very many states that have kind of explanation or a preamble to their law. When I say that, a lot of the came from media sources where the proponent or the legislator that introduced it said, this is what we're doing. So a lot of this kind of wasn't formalistic in the bill. But it could be, and I think that there's so much attention, and already many people know the purpose of this law or a proposal.
Any other committee member questions here in person?
This is a bit of a curiosity, but maybe in the beginning it'll make a difference. But so I understand that foreign interest owns around 40 million acres of ag land in the U.S. How many acres of foreign ag land do the U.S. interest own? Do we know that?
I get that question, and I have looked and looked and looked, and pretty much what economists concluded was like, we cannot conclude that at all. There's just no way of knowing where the interests are, because other countries generally don't have something like a FIDA, or I have not found any other country that keeps tabs on U.S. ownership in their country. And of course, it's sometimes really difficult. And I don't particularly want to get in the weeds with a FIDA because that thing is I've touched the bottom of the swimming pool on it, and I come back up for air, and I still am like, this doesn't make sense. Some of this stuff just runs you in circles when you start looking at how the federal government has structured this law to, particularly USDA, has structured the reporting requirement. So structuring business entities, establishing a entity over in another country that's actually backed by a U.S. entity, that's kind of hard to determine if that's actually U.S. interest in that ag land over there. So same thing goes for over here in the U.S. So it'd be difficult to actually put a number on it.
Ed, do you mind if I answer his question?
Well, if you can just hold off just a few minutes, I want to make sure there's no more committee questions. We're going to try to wrap it up by about 11:30. Yes, Mr. Allen.
So, Michael, just to kind of summarize, at least the way I see it, most of these laws that have been enacted in these other states really come from the basis of national security. Not so much opposition to general foreign ownership of land, but national security. And the same thing goes for the federal law. Is that correct?
That is what I've seen.
Okay, so the reason most of these state laws put in there, the big four, or put in there to be determined by the federal law who those countries are. So those adversaries in those countries can change the way these laws are written.
They can change.
They
Yes.
can change. So that pretty much protects you from a national security standpoint. I guess the question would arise is some of those change, are they grandfathered in when an adversary becomes a friend, or vice versa?
Based on that definition, it seems like it would change with the times. And states that have used a federal definition, specifically an actual federal register citation to it, it's going to change exactly when U.S. Secretary of Commerce, Secretary of State changes their list, changes whoever's a foreign adversary or whoever's under that list, it will change the state law as well.
But anyway, just the big picture is about national security, not about taking away private owners' rights to sell their land, not opposition to foreign ownership of some of our land, but national security is the basis for these laws being enacted, and it probably should be the basis for any law that we enact.
Correct. Yep.
Thank you. Any other committee questions? Madam Chair.
So since you've been answering questions from the committee, you just really talk about the importance of definitions. And so we're supposed to make recommendations. Would you have any recommendation with respect to any particular definition or any amendments that we possibly should include in our statute?
I go back to being very detailed with the definitions of what actual foreign investments the state actually wants to prohibit. Like the Florida example is perfect where they just said domiciled. That was an issue, and that was something the plaintiffs could cling on to bring this challenge against the state. Also, another interesting argument is if a state does not attach their definition to a federal definition, such as Florida, it could be like they're establishing their own foreign policy as well, which is, in the eyes of probably legal scholars, would be a big no-no for them, because that's a federal government role, is to determine who is an adversary of the U.S. And so it could seem like the state is establishing foreign policy in their own state. And then some of just keeping in mind there are consequences to enacting some of these laws, namely crop protection companies with a research experimentation exception, possibly. And the biggest exception and carve out would be tailoring a restriction to specific countries. That's the biggest exception. Because like their traditional pre-2023 laws, they don't seem as restrictive on their face to these new laws. But when you really compare the two, the traditional foreign ownership laws restrict, it's kind of a blanket restriction. We're restricting everyone from China to Canada. But these new 2023 laws are tailored towards specific countries. Another thing is identifying the actual parties you want to restrict, whether that be individuals, entities, or government political parties, a combination of some or all of these actors, where you can see Alabama only restricts the government and political parties, where other states like Arkansas, Florida, and quite a few other restrict pretty much across the board, individual entities and the government.
So does that answer your question? I would follow that up with, you don't have to answer this now, but I'd like to know your perspective of the states that we know that have acted on this, who's done the best job of it. Is there a model piece of legislation out there, or could Mississippi become the model piece of legislation, which I think would be a great thing for us to do, knowing that we need to at least bring some clarity to our existing laws. Do you have any thoughts about that you want to share today, or you want to think about it and get back to us?
I get that question often, and really it comes down to, it's very situational within the state. What might work in Mississippi probably be different from Nebraska, for example. Lots of forestry investments in the state. Really, I don't know if there is an actual model piece of legislation that would encompass all the interests of a specific state.
Yeah. Right. Any other questions? On the committee, online, does anybody have a question online, or who's on the committee joining us by teams? They do? Yes, you're recognized. Okay, hold that, we're going to turn you up a little bit.
Is that all better?
Yeah, that's great, thank you.
Okay, good. Mike, thank you for the presentation. That was really informative. You kind of alluded a little bit to this, but going back to the 40 million acres of foreign ownership currently in the country, the breakdown between forest land, crop land, and other land. Do you have a further breakdown, particularly like within the forest land, which we see a lot of Mississippi, of what is of that, I think it's 47%, so almost 19 million acres in the country. How much of that is just individual investment, foreign entity investment versus which a lot of the forest land would be, TMOs here, United States entities that have venture capital money, other investment money coming in, running through them, that they actually manage the land. Do you ever break down on that would be long?
There is not a specific breakdown. To a sense, USDA actually just released more of a detailed look at the data that they've collected. Usually it was just kind of general numbers of what the foreign ownership is, specifically in forestry in Mississippi or something like that. They actually have these downloadable Excel sheets now where you can look and see what entity actually owns the dirt. It kind of goes back to a FIDA where it can get tangled, where there could be some level of foreign ownership under that entity or under that individual even. It could be an individual purchasing that forest land, and they are backed or acting as an agent for an entity that could be even domestic or foreign. So once again, it's really hard to determine an actual number of who's owning this dirt.
I got you covered. Thank you.
Yes, sir.
All right. I don't see any other committee questions. If there are, speak now. We're about to wrap this thing up. Okay. I don't see any, but I do have a special request from Mr. Pettit, Bubba Pettit, who was here at our last meeting. He's in the meeting today. He submitted actual comments to us, and and he knows, he's an attorney, and he knows a good bit about this issue. He asked special permission to ask a question today and to say a few words, since he's not going to be able to be here at our next meeting. Is it all right with the committee if Mr. Pettit is recognized right now? If not, if so, I'll do that.
Y'all be glad to know that I won't be here next time. I'm bringing my daughter back, my granddaughter back from Italy, so.
Good. Go to the microphone, if you don't mind speaking, so they can hear you online. They probably won't be able to hear you unless you do that. And we're going to try to wrap this thing up before lunch. Yes.
Yeah. All right, Meredith, I want to answer your question. When this thing got started, Jason White became aware of the law, and Jason's not a military man. I was in ROTC 1 year. We're not military, but this is not about foreign security, although that is a very, very valid concern. What our deal is about is the effect that it's having on our state, and the fact that lawyers, competent lawyers, have abided by this law. This isn't some law that came about and said, this has been there for years. Competent lawyers have abided by this law for years. So we're concerned what it's doing. Ted, in answer to your question, I have a partial answer.
When you pull that microphone up, yeah, pull it over. This sound bounces around.
I'm sorry. And
That'd be great.
I spent 46 years in front of a microphone singing rock and roll music, so I should be.
Go ahead.
Have the ability.
Thank you.
All right, Ted. The Netherlands citizens and / investors, all of the people in the Netherlands, they own more timberland in my county, Atala County, and my neighboring county, Lee County. They own more timberland in our two counties than they own in their entire country. So what you've got is we've got this wonderful market over here. And I mean, Andy already answered this question when he said we fought a war. That's the reason this thing is in this 1892 Constitution. I haven't researched it, but I'm saying it's in the 1817 Constitution. And the comments I gave the other day was, what are they doing? Are we going to know who voted to sell to the farmers? And my daddy did 2 tours in Vietnam, and we're going to sell this stuff to all these other folks. I have a little more answer for your question. You can buy land, farmland in the Netherlands if you can find it for sale. It's going to cost you $25,000 to $75,000, $50,000 per acre. I had to convert the hectares to acre and all that junk.
Wow.
So, but what's going on in the Netherlands, and this is what's driving people just nuts. The Netherlands, they're in the European Union. They got all this green tree stuff. So they are kicking their farmers off the farm. Did you know that? They have, in the last just 2 or 3 years, somewhere around 2,000 farms in the Netherlands have been confiscated, eminent domain, by the government. And the farmers are furious. They're doing it because they're so efficient. But by being efficient, they emit way too much carbon into the atmosphere. So because they are in the European Union, and part of that, I don't know, Kyoto Protocol, whatever you call it, they have to buy land. I mean, they got to quit farming. So what do? They come over here and buy our land. Now, if they own 2.6% of our agricultural land illegally right now, when you open those floodgates, it's going to be like you see those people on those trains crossing the border. You know, they're all hanging off the train and they're waving, coming in thousands at a time. You're not going to believe what's going to happen by the way. That's my opinion, and that's the people that I talk to. We had a...
before they get over here, buy the rest of it before they buy it.
Do what now?
I said, you didn't buy the rest of it before they buy it.
All right. My forestry group, we had a group about 50 people. This was 2 years ago before we approached the Attorney General. And out of about 50 members, we represented landowners from 6 counties. We had actual timber land from 9 counties. We passed a unanimous resolution to present to the Attorney General to enforce the doggone law. And I'm not gonna take, I don't have a minute to, I'm not gonna take the time to explain the adverse effect that they're having on our tree farmers, but it's killing us. And we need, and we got confidence in you, and I went to a meeting last night with Jason White and Farmland ownership, like came up, I mean, everybody was pumped. It was really, really good. I'm gonna tell you a story. I'll be quick, Andy, I promise. The kids from our county and 4 other counties go to school. We have Talla, Choctaw, Montgomery, Carroll, and Webster. They get about between $4 and $5 million a year in scholarships. It's one of the biggest scholarships at state, at Ole Miss, at the Med Center, and at Mill Center, at Holmes Community College, far away the biggest at the Med Center and Holmes Community College. That money came from a man who owned, E.H. Summers, owned 25,000 acres of land in that district. And when he died, he donated that money for scholarships for those kids. We have another man who don't own land, donated a lot of money, and I'm real active in that program. And we have an individual that gives almost $40,000 a year for scholarships. All of that money comes from timberland. Most of it is in Talla County. Almost all of that money comes from timber. If we allow these folks to come in here and continue to buy this land, I mean, we don't have a shipyard in Talla County, and you don't have any farmland in your county. And I respect, and the people on this whole committee don't have as much, all 9 people, I only have about 70% as much foreign-owned agricultural land as we do in Talla County. I mean, I respect everybody's opinion. Everybody's got their opinion. That's just the way for y'all to work it out. I mean, that we, those of us who don't want it, maybe we don't get it. Y'all who want it, keep it. But I had a young farmer tell me, Bubba, I cannot compete against these farmers. I farm, I want to own more land, I cannot buy it. And I said, well, we're working on it. Anyway, so, one more thing. Micah didn't touch on it, cutting you off, tell me to sit down, please. Micah didn't touch on it. But in the Attorney General's opinion, Mr. Lipscomb, you made the comment that this doesn't apply to the Dutch. And so we've been talking about it. I reread that treaty, that Dutch treaty. All of this is because of the internet. Where would I, in Talla County, gotten a copy of the 1956 Dutch-American Friendship Treaty? It does not give the Dutch the right to own agricultural land. Does not do it. Micah, you want to speak to that?
I'll say this, Mr. Bennett. I think the opinion actually says we don't speak to the treaty.
Well, it was very misleading.
We don't.
Anyway, could you give us a clarification?
We're gonna, actually, I talked with Ms. Lipscomb before the meeting, and I think there are some additional questions that we can argue with those that are arising from this committee work, and we're gonna be able to pose that, and they're gonna be able to answer them in due course before the deadline.
One other thing, you may not have to worry about this because the title insurance companies don't buy the opinion. And I know that 2 of them, we have 6 in the state, 2 very small ones and 4 major title insurance companies. And I'm not quoting this as fact, but I'm getting the impression that title insurance is not going to be written on this land anymore, at least from some of the companies, because they understand the law, they disagree. Anyway, I have a group of 9 lawyers, and we've all interpreted that thing a different way.
Yeah, that's interesting information.
One more thing,
All right.
and then I'll shut up. Yeah. The word eschew, that's the death penalty. You talked about enforcement, and all this stuff, and how you do that. When they put that word eschew, in 89, 123. In other words, they were saying, you're gonna get the death penalty. We do not want this to happen. And that is, chief, is the death penalty. It's not a mild thing. Anyway, you ready?
Thank you, we appreciate it, and thank you for bringing that to our attention. Now, we do want to thank all the members of the public, and I want to say that it is my intent that we have some testimony at the next meeting, certainly October 19th. And the way to get in line to do that, if any group interest, if any citizens, if any landowners would like to be recognized to give testimony at a limited time. We don't have time to talk about it 30 minutes times 50 people, but we'll have some limited opportunity for testimony, and that testimony would be preferred to be written out and submitted in our comment system, which is farmland@mdac.ms.gov, and that can be done before our next meeting, October the 19th. So, in the meanwhile, if you have comments or thoughts about what you've heard today, you can submit those by email. Those will be made part of the record here, and we're going to be providing that all to the legislature. I will conclude with these thoughts. I too was at a forestry meeting last night. I went to Clark County Forestry Association annual meeting. I get invited to speak around the state. That's a good bit of what I'm doing these days. Listening to people, talking with people. And I can tell you that the sentiment of the people of Mississippi is that this is a major issue that needs to be addressed. There's nothing I talk about that gets more response from the people of this state than this issue right here on the subject of something as simple as keeping American agriculture American. And I'm convinced that the legislature will feel the same way about it after we get all the facts and all of the information in the record here. I do think this presents this task force, this study committee, a unique opportunity to get this right versus just passing something for the sake of passing something. And I do think that the legislature, the House and Senate were very smart and wise to assemble this thoughtful group so that we don't have unintended consequences. That being said, there's a lot of ground for us to cover between now and December the 1st. So our next scheduled meeting is October the 19th. We will roll out a proposed agenda on that. If you would like to be heard, if your organization, if your group, we can't have, as I mentioned, dozens of individuals speaking for a long time. But if your group would like to submit some short comments or thoughts, please do so. Let's just set, since our meeting's October 19th, let's set a deadline 1 week before that, October the 12th, to email your request to do so and a copy of your proposed remarks. Okay? And we'll try to keep them to 2 to 3 minutes each. Then we'll have any other agenda items will be sent out to the committee and to the public in advance. Are there any other discussion or other business? If not, I'll entertain a motion that we adjourn. Second. All in favor, say aye. Thank you all for coming today. Appreciate your work.